I wanted to move on to issues involving discovery time limits and how you feel that that assists you in moving the docket. Anybody? Judge Davidson?
Well, I'll chime in. I think it's a good idea to put a limit on discovery and time limits. I think it works. It's if you need relief from it, move. But you have to conclude the plaintiff's deposition at some time. It cannot go on endlessly.
Do you have time limits in your jurisdiction?
I'm embarrassed. I think we do, but I don't know. I never get into that. I think we have 20 hours. You want 20 hours? Am I right?
That's right. 20 hours?
Okay, I have two people who don't normally agree with me telling me I'm right.
We definitely have time limits and on discovery, and I think if you don't have them, I don't know how you're ever going to get the cases finished in time. You have to do. And most of ours are provided for in our standing order, and I think both sides of the bar have pretty well agreed to those time limits. Every now and then we get a request to go outside the limits for some exceptional reason, and we might allow it, but ordinarily everybody lives with that order.
We have a 6-hour time limit set forth in the rules of civil procedure. When I first got this asbestos assignment, I was told by the defense side of the bar that 6 hours isn't close to enough, that we need 10, 12, 15 hours because we have 52 defendants, all of which need to ask their questions. Well, I went and read some of those depositions, and what you had was a bunch of baby lawyers going around the nation with a list of questions they had to ask, and they were largely the same. And so the plaintiff or the witness was getting asked the same questions time and time and time again. So I told the lawyers, I'll tell you what, I'll give you 30 hours if you need it, but the first time a duplicate question is asked, the deposition is over. And they quickly decided they could live with 6 and just do a little bit of coordination between them as to which baby lawyer was going to ask which question. So I just saw a lot of repetition in the depositions that I read. For people that said they needed, 15, 20, 100 hours to take somebody's deposition.
I have a very laissez-faire attitude toward discovery. If you don't bother me, I don't care if you're doing discovery when the jury comes in with its verdict, as long as you're ready to go on your trial date. As far as time limits, I think in my first tour of duty I established time limits. I don't remember what they were, and I bet nobody follows them anyhow. But as long as they don't fight with each other and the things get done, that's all I care about.
I inherited a CMO, and I believe our CMO says that you have 3.5 hours to depose the plaintiff. I think I would be a very rich person for every plaintiff that was or was not deposed in 3.5 hours. I have a concern, as you do, Judge Davidson, about time limits and questions being asked over and over again. But I remember vividly watching Les Mis with Charles Lawton saying the law is the law. And there is not a time when someone will call me and say, Judge, we need more time. We have so many more defendants here. And as long as they don't do what you said many times happen, the same question asked over and over again, including, and I've read some of these depositions, what is your name, how old are you? And some of the people who are being deposed are on a deathbed. And we're going to make some changes in New York.
And in Los Angeles, first of all, the general rules of civil procedure with regard to this discovery apply in asbestos cases. However, some judges in their individual courts are formulating specific case management orders for the particular case that is in front of him or her. And oddly enough, that in many situations where a judge is trying to expedite discovery and try to bring the case to a head earlier and try to make it more efficiently, the lawyers are objecting. The lawyers are resistant to having discovery completed earlier and even want delays more than the normal process, because in a regular case, the rules under the Code of Civil Procedure provide for a discovery complete 30 days before trial, and a lot of the asbestos cases, lawyers want it much sooner to the trial date. They don't want to have to spend the money for deposing any experts that they don't already know whatever they're going to say. And so they wish to delay the the completion of discovery, notwithstanding the fact that the settlement discussions are also delayed, as I mentioned earlier. As far as the particular time limit on deposition, we do not have a time limit now. However, it's under discussion in terms of amending the general orders, and we've had some hearings on the proposed amendment to the general order, whether there should be a time limit on completion of the plaintiff's deposition. And it's a hotly contested issue. Obviously, the plaintiffs want a limit on the number of hours. The defendants, most of the defendants do not want a limit. Some of the defendants are agreeable to a limit, but want something traded in return, and that is to more requirements on the plaintiff to produce all the documents and all materials earlier before any of the depositions begin.
There isn't a trial judge in America on discovery issues, whether it's the length of depositions or what you have to produce or what you've got to do in any aspect of discovery, that doesn't follow the Jagger doctrine of discovery. Now, that's not Jagger versus Topeka, Atchison, and Santa Fe Railroad. The Jagger doctrine states that you can't always get what you want, but if you try sometimes, you just might find you get what you need. There isn't one of us, regardless of time limits, that isn't going to give everybody all the time and resources they need to go to trial, but that does not. But you do not need to ask questions repeatedly, and you seldom need to take depositions longer than a certain amount of time. They need 3.5 hours in New York, and for the life of me, I don't see why they need 6 hours in Texas. But I'm going to follow the Supreme Court's rules. If I were to say 3.5 hours, they'd get it done in 3.5.
Sure.
And
We
if
talk
they need
more quickly in New York.
And if they need, yes, yeah, we talk a lot slower in Texas.
Right.
But no, but in this, as in all things, just anytime 6 hours isn't enough, 3.5 hours isn't enough, 20 hours isn't enough, ask and explain what you need and not just want.
Also, in our discovery, we use depositions from other jurisdictions. And I won't let people be redeposed unless they show me an area that was not covered. And given the fact that what Judges Heitler and Davidson are saying is true, I think everywhere people ask too many questions, and so there's rarely, if ever, a line of questioning that needs to be gone into again. So that's part of how we streamline discovery, too.
There is, and I'm not sure that it's a good thing, but under our standing order, the plaintiff has to give the defendant 7 days, I think it is, between the time from their discovery deposition of the plaintiff until they get to take the evidence deposition.
Well, the hammer that is on the plaintiff, however, is the plaintiff is not forthcoming, then there's always a risk going back to the judge asking for a second session. Now, if you're worried about a plaintiff passing away, the risk then is that the court would exclude the testimony because plaintiff had not come forward with a document to allow a complete, fair deposition by all the parties.
Does anybody think it would be fair to limit the plaintiff's direct to, say, an hour?
Well, it depends on the circumstance. I think the case you posit is somebody's using a deposition for trial purposes. And trial purposes, obviously, the testimony in that trial is going to take more than an hour, so I'd be very surprised anyone would limit as possible, not giving advisory opinions, but depending on the facts and circumstances of the case, if it is truly a trial deposition to preserve testimony for somebody who is at the risk of an early death, then obviously a deposition has to be taken in a different manner than just a discovery deposition.
Robert, let me answer your question directly. If the plaintiff's lawyer is smart, he'll probably keep his client's deposition, his client's trial use deposition to an hour. Because if you if you're going to represent to the jury that your client is dying and lives a miserable life and can't, talk for long and survive for long, being able to stand there and give a 6-hour or 3-hour deposition is unwise for the plaintiff. So to answer your question is, would it be fair? No, but if the plaintiff's lawyer is smart, I won't have to make the determination of whether it's fair or not.
Right. Yeah, I agree with that.